Good afternoon, dear friends and colleagues and participants out there. Today's webinar is a continuation of a series of webinars that you have already had the opportunity to enjoy here, presented by colleagues in the energy community, and we continue this experience with a session on energy dispute and its resolutions. So energy dispute, evidently, and dispute in general has a rather negative connotation. What we would like to take you through today and also to convince you about is that dispute is A, a fact of life, B, it is a necessity to find good and appropriate means in their resolution, and C, they are a chance and offer a chance to turn negative energy into positive energy and to clarify further the rules that apply in European and international energy law and policy. We, that's my colleague Smaranda, Miron, and myself, we have shared this presentation and split it into 4 parts for you. I will take over the first one, which will cover general aspects and the basics of European energy dispute resolution, so dispute resolution under European energy law. Smaranda will then cover the international aspects of energy dispute resolution, while I will take over again to tell you something about the specific energy community experience, and then again Smaranda will tell you about our experience and the cases and the instances of dispute resolution we had in terms of mediation. So that's a full program, and I hope you will enjoy and happy to listen afterwards to your comments and questions. But let's get diving into it. Smaranda, I assume you are ready as well, and the presentation is uploaded so that you can see what we are talking about. We start with an introduction into what dispute resolution in energy law means. There were consequences when Jean Monnet, who is one of the founding fathers of the European Union, decided to build the European Union and integration on the rule of law. It is said that he later regretted that, but the consequence evidently is very visible in the energy sector, as opposed to other ways of integration, other possible ways of integration. Let's think of the technical way, for example, an integration which would be based on standards and technical norms only, as opposed to such a technical integration. The rule of law and the fact that European unification and integration is based on legal rules brings with it a certain impreciseness. Legal rules are evidently not fit to cover an infinite number of situations and disputes, and also it brings along a very specific way of dispute resolution, the legal way. The law is not an exact science, as engineering may be, or physics. Doesn't mean that the decisions are arbitrary, but it is something that we have to keep in mind when we go now into the world of disputes and dispute resolution, especially from the European perspective. It's all based on a decision to integrate Europe on the rule of law, and that's a decision that was later replicated also by the energy community. Evidently, a dispute needs an arbiter, and in the European Union, according to the institutional architecture established by the treaties, that is the Court of Justice, located in Luxembourg. The Court of Justice is the ultimate dispute resolution body, if you'd like so, and it addresses not disputes between private persons, but its role is of a constitutional nature, so it's supposed to contribute to the appropriate sharing of competences in a very complex legal order, such as the European Union. It is based on the so-called acquis communautaire, so not on general principles like they prevail in arbitration of fair and equitable treatment. And it also follows a specific methodology, the methodology of legal interpretation. This, in terms of international law, is laid down by the so-called Vienna Convention on the Law of Treaties, and I may quote, "A treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose." That is something that every law student knows. However, the European Court of Justice did not necessarily deviate from these principles, but based its rulings on a more functionalist approach, a more integrationalist approach, a wish and a desire to, while resolving individual disputes between institutions and sometimes involving individuals, also and always contributing to the development and to the consolidation of European law. That's also an important aspect to be kept in mind. In the United States, evidently, that would have immediately caused a reproach of judicial activism, but I think in Europe the perception is much more benevolent, and the European Court of Justice is indeed seen as a driving force, a motor of European integration. Let me give you a few examples, which I consider a best-of list of cases in the energy sector that essentially provide evidence for what I was just saying. And as any best-of list, this one is also subjective, and it has to start with something that, again, every law student knows very well. It's a ruling called Costa versus Enel that is concerned the case. It was handed down, so decided by the Court of Justice in the early 1960s. It concerned the case where Mr. Costa sued his utility for the total sum of less than €1, and yet the Court of Justice did not miss that chance to turn it into one of its greatest cases ever, establishing what is called the supremacy of European law over national law. The next set of cases I would quote here is from 1997. It's also important, maybe less for the general European integration history, but certainly for the liberalization of European energy markets. That was a set of infringement cases. I'll explain you in a minute what that is, where the Court of Justice was asked to look into one of the key obstacles of liberalized energy markets, national vertically integrated undertakings, and especially in the aspect that was back in the 90s, still very common in one aspect, and that's a monopoly of these local incumbents to import and export electricity. And the Court of Justice found in these cases that such a monopoly is an exclusive right, is discriminatory. That is something that had a very strong and loud echo in the capitals of the European member states. The Court of Justice could not finish that case by finding a breach of European law, because at the time European energy policy was still in very premature stages, and the Court of Justice had to ask itself and had to ask the European Commission, the initiator of the cases, back, without a guaranteed third-party access and without a guarantee that if you let in competitors on the import-export sector or section only, then you risk challenging the whole system and the whole basis on which energy was founded at the time, and that is the idea that the expensive or the well-paying customers subsidize the less well-paying, and hence this element of cross-subsidization was not resolved through secondary legislation, so the ball was being played back by the Luxembourg judges to the legislator. But the principle was an important one to kick off this whole process of liberalization of European energy markets. I was mentioning third-party access. that indeed was later enshrined in directives, as you all know. It's one of the key principles of European energy liberalization. And why is that one of the key principles? Not only because it was put into directives, but also because the Court of Justice didn't miss the chance to establish that case, that principle, in a case relating to imports to the Netherlands, which were linked to a capacity reservation, so reservation of network capacity in order to honor these import contracts that Dutch utilities had concluded. Court of Justice didn't miss the chance to make sure that this third-party access principle is up there with the most important European law principles, a fundamental principle of European law, and does not tolerate any restriction or any statutory reservation. Again, an important case. And as we are talking about liberalization, I'd also like to include into the picture two more cases which deal with different angles of the so-called energy policy trilemma. As energy policy aficionados among you know, European energy policy was for a very long time, if not still today, based on a triple functionality, a triple objective. One is the liberalization of the market. The second one is the provision of and the guarantee of security of supply, and the third one, sustainability. Now that sounds and is of course a political choice, but the Court of Justice was instrumental in these cases as well. And again, its involvement and its rulings go way beyond settling individual disputes only. The first of these two cases related to security of supply, and which happened in the wake of the oil crisis in the 1970s, concerned a refinery in Ireland and the obligation to purchase from that refinery. And there the Court of Justice established security of supply as a key principle of public security of member states, which they could use as a defense against or in cases concerning fundamental freedoms. And only later this perspective was changed by European politicians, and security of supply actually became an integral part of European policy as well. The second of these cases is the famous Preußen Elektra case, famous because it opened the door, and consciously opened the door, the legal door, to member states supporting renewable energy generation without having to worry, at the time at least, about key principles of European law, like the fundamental freedoms or like state aid, because the Court of Justice in this judgment gave them a relatively far-reaching carte blanche, and telling member states, if you want to support renewable energy, this is beneficial. And that's already in an early case in the early 2000s, this is beneficial for our fight against climate change. And you may do that, and this triggered, evidently, or at least it helped, a wave of support to renewable energy, and thus kicking off what we call today the energy transition. Let me finalize this first part of the overview of what energy dispute resolution in European law is by a brief insight into how Kirchberg works. Kirchberg is the place in Luxembourg where the Court of Justice is located, and maybe there are a couple of myths about judges in general, that they are some kind of philosopher kings sitting on the mystical mountain and coming down with wise and fair rulings, which we all hope that they mostly do. But evidently there is a cuisine also inside these courts. First of all, there are no single judges normally, so they always have to find compromises among themselves, and judges tend to be political animals, just like everybody else, or even more than everybody else of us as well. But their problem, or they want to follow a political agenda. The issue, the specifics of judicial decision making is evidently that you cannot determine your agenda by yourself as a politician. You are depending on what comes in, what kind of case you get on your table. And in developing out of this certain arbitrariness, a structure, the Court of Justice has developed a special technique, and this is, I call it the Lego technique, because what they're doing is that, and if you read judgments by the Court of Justice, you see that confirmed, that these are building blocks, like Lego blocks, from which you can not only, or by which you can not only solve the case, but you can also use them for developing a body, a stringent and structured body of case law. We don't have a stare decisis doctrine in European civil law. In European civil law, le juge n'est que la bouche de la loi, as Montesquieu has put it. So this technique comes very handy to actually take an influence on the development of European law, and I illustrate this with a set of cases related to public service obligations, which in the European energy directives have been introduced as a possibility for the state to intervene into what are supposed to be liberal markets. But this introduction into the directives wasn't a very clear-cut one. It was a typical formula compromise, politicians not being able to solve this evident tension between liberalized markets and state intervention. So it was left to the European Court of Justice to resolve this very fundamental issue, and they did it indeed by starting with the first case, developing a text for when a public service obligation is excessive, and refining that with consecutive cases until now we actually have quite clear rules what it means to draft and apply compliant public service obligations. That was just a brief overview of the role of the Court of Justice in energy dispute resolution under European law. It is fair to say that the Court of Justice has developed and has turned itself into a point of reference, not only in the EU as it should, but also in the wider European sphere. We'll be talking about the energy community in a minute, and also in the international sphere. And with having said all that, I will hand over to my colleague Smaranda for the next chapter. Thank you.
Thank you very much, Dirk, and good afternoon to all of our participants to this webinar. I will continue. I'm sorry, the present. I apologize, there's some problems with the presentation. That's not moving. Okay. Okay, apologize for this. I'll continue with a few remarks about international energy disputes, what makes them different, and most importantly, how do we solve them? There are so many facets when it comes to an energy dispute that in most of the cases, this is much more complex than just an average legal battle. And this is because whether we actively acknowledge it or not, the energy disputes are very deeply intertwined in our everyday life. For example, energy prices and energy policy can make the difference between winning and losing an election. Countries which have the resources, the energy resources, have extremely important geopolitical roles and so on. And then also, the whole field is extremely diverse and is continuously evolving. We have a multitude of energy resources, transactions, actors, and stakeholders. And because this field is developing, of course, the legal part is also developing together with it. And the energy law is not static. It's a very fast developing organism, and probably nowadays much more than other fields of law. This is why energy disputes are uniquely complex. But when it comes to resolving them, we still appeal to the traditional way. So we have litigation, which means the parties take the dispute in front of the court of a state. Arbitration, when the parties appoint an arbitral tribunal to make a decision on their dispute. And finally, mediation, when the parties this time appoint a neutral mediator or facilitator, not to decide, but to support them in finding mutually agreeable solution. Now I'm going to take you through 3 sectors of energy in which, and then present you the types of disputes that can arise in these sectors. And we're going to start with the oil and gas. These are, at least in international dispute settlement, these are the traditional energy disputes. How do they originate? Well, in the first place, you have countries rich in reserves that at some point grant very generous concessions or long concessions to petroleum companies to exploit the respective reserves. But when something happens and there's a change of government and a change of national policy and so on, and these concessions are amended, terminated, or the legal framework is being changed to the detriment of the investors, then these investors, of course, go before courts or tribunals to find justice. And Latin America is a very good example when it comes to disputes between large oil and gas companies and sovereign states. And within Latin America, Venezuela, for example, is the country which has the highest proven oil reserves in the world. Well, this is an asset, but it also, throughout the years, gave rise to landmark disputes in the field. In the early 1990s, Venezuela started a very open policy of opening the market towards foreign investors and offering them the opportunity to exploit the natural resources. And this is when companies like ExxonMobil or ConocoPhillips decided to invest in Venezuela. But when President Hugo Chavez came to power at the end of the 1990s, he took a different approach. And the legal framework upon which the companies initially invested was gradually amended. I think the worst or the most detrimental measure that was taken by the Venezuelan government in the late 1990s was the fact that for an investor, in order to be able to conduct business in Venezuela, could only do this in a partnership, in a joint venture with a local company, and the local company always had to have the majority of the shares. But some companies agreed to this approach and found ways to go forward, but other companies, for example, like ConocoPhillips, decided to go to arbitration and to ask damages for what they consider to be expropriation. In the case of ConocoPhillips, it's an interesting case. They filed for arbitration in 2007, and the final word on damages was released only at the beginning of last year, then rectified at the end of the year, and as we now stand, Venezuela needs to pay to this Dutch consortium $8.5 billion in damages, and currently the award is being challenged by Venezuela in an annulment procedure. Now, especially today, if we talk about international energy disputes, of course, we have to talk about renewable disputes, and these are particularly important when it comes to the European member states, but also becoming more and more visible in the neighboring countries of the EU as well. Similar with the oil and gas disputes, what happened in the first place was that European member states committing to promote clean energy were granting very generous support schemes to companies in solar or wind sector, and this was the case of Spain, Italy, or Czech Republic. But then after a couple of years, the situation changed, and what these countries then claimed was that either the financial crisis affected them, or there were tariff deviations, or the production of renewable energy was so high that they could not pay. So what they did was to slowly revoke, slowly dismantle these advantages that for the investors it seemed no longer profitable to do the business. under conditions which were very much different than the initial conditions. Spain here is the best example. There have been so far around 50 international arbitration cases filed against Spain. I think it was 2013 when we got the first award that was public. And as we know it today, most of the awards were in favor of the investors. Some awards have not been publicized. But interestingly enough, whether the ruling is in favor of the investor or in favor of the state, most of these awards have this bottom line and deal with this very important question: what is legitimate expectation, and can a legal framework give rise to legitimate expectations on behalf of an investor that the legal framework will remain unchanged for the whole duration of the investment in the country. And unfortunately, for the legal certainty, different awards dealing with the same legislation in Spain have interpreted the standards very, very differently. So, for example, in the case of Nextera versus Spain, the tribunal said that the framework is based on, if the framework is based only on legislation and no specific promise, then the investor must know that legislation can be changed, and you cannot expect to have the same projected returns based on the initial framework. This was an award that was issued in 2019. And another award issued also in 2019 is Cube Infrastructure versus Spain. And there, the tribunal said no. On the contrary, in such a highly regulated sector like energy, it is this very regulation that must give rise to legitimate expectations. So interesting field to watch, and the beauty of investment arbitration and also the burden. There is no such thing as an institute of precedent. So it's at the end of the day, it's about how you interpret and how you argue and how the tribunal sees it. And finally, the last field of international disputes that I would like to talk about is the climate change dispute. As you all know, the body of climate change law continues to grow nationally, internationally, and so on. And the more regulated this field becomes, the more the risk for companies, for the big polluters, for example, increases, that they will be sued and brought in front of tribunals or courts for the detrimental effects on the environment. It's a very interesting case to watch. There was a Peruvian farmer who sued one of the biggest German companies and one of the largest polluters in Europe in front of German courts for alleged contribution to climate change, which is threatening his home. And his home is in a village in Peru that is very close to a glacial lake. Now, interestingly enough, this company does not have operations in Peru. The first instance, court in Germany, first of all, said they don't have competence, and German law is not applicable to this dispute. But I think it was 2018 that the regional court of Hamm said that there is such thing as the responsibility of a large emitter for damage or risks in foreign countries, as long as science can prove even a partial causation. So the standard was kind of lowered from full causation to partial causation. So the case goes on in German courts, and as far as I know right now, they are in a phase of taking evidence. And to conclude this part on international dispute resolution, I've put together this short checklist for all the sides, for investors that are doing business or that plan to do business in a country, for state authorities. It is a very hectic field, and then I think you should do your best to minimize the risk. So first of all, even if everything is great in the beginning, you have to know what your dispute resolution clause says. In a contract, for example, you have to negotiate it. You can negotiate on the applicable law, on the applicable forum, number of arbitrators, so make sure it's something that if a dispute ensues later on, you can live with. Then you always have to know the applicable laws, and not only the energy law, electricity law, gas law, but the whole system of the country in which you are investing. For example, how can laws be amended? What's the hierarchy of laws? Because this is going to be very important at a later stage if a dispute will come up. And of course, it's not only national law, as you've seen now and also from this presentation before. We are subject to all kinds of layers, international agreements, bilateral, multilateral, like the Energy Charter Treaty, regional agreements like NAFTA, and all of these come with different substantive standards, different procedures that it's good to know, and so that you can have like this menu of options. Especially if you're a foreign investor in a country, have clarity on what you promise, or on what is promised to you. Just make sure you have a good understanding what is the state or the state authorities promising to you. And if you are a state, of course, make sure you say what you want to say, so that it cannot be differently interpreted at a later stage. If you're an investor, you can ask for stabilization clauses. If you're a state, you want to have maybe an acknowledged right to regulation. And always you have to see everything in your investment and your business in a much broader context. No man's an island on its own, and also no country is an island of its own. Especially, for example, if you invest in one of our contracting parties, most of them in various stages of accession negotiations, then you have to know that at some time in the future, these countries will be member states of the European Union, and then a whole new body of law is going to apply, and everything is going to be much more regulated. Okay, that's all from me, and I'm sorry if I talk too much, and now I'm going to pass back to Dirk for the third part.
We will be talking now about the energy community, which will be coming closer to home. I hear an echo, I can handle that. And before going into the specifics of energy community dispute resolution, I think it deserves a few words by introduction, because the energy community is indeed an example of where the European Union exports its laws to neighboring countries. It's not the first one, or it's the only one. Maybe the model for all these agreements is an agreement which was concluded already back in the 1990s, the so-called European Economic Area, EEA, and that still today sets the gold standard not only for sharing a legal space between the EU and its neighbors, but also for taking care of a homogeneous enforcement and the dispute resolution of what is essentially the same rules. In the EEA agreement, this was done by a duplication of structures. So the non-EU countries which participate in the EEA agreement, they have their own court and enforcement authority, whereas in the energy community, there are common institutions also taking care of dispute resolution. That's an interesting difference. You have other examples evidently as well. You have, for example, bilateral agreements between the EU and some of its neighbors. The most interesting is yet to come. That will be the United Kingdom, but we can look at Ukraine, for example, an association agreement which is vested, or where the institutions are vested with political dispute resolution powers, an association council, and arbitration is interestingly also included as an option to resolve disputes, because why not going to the European Court of Justice, the same institution that I praised so much in the initial part of the presentation, because evidently it's one party's court and not one that would be perceived as independent in that respect. But in all these instances, be they multilateral agreements like EEA or the energy community, be they bilateral agreements, what is very important, and that again relates back to what we've been talking about earlier, is ensuring homogeneity. So that the fact that rules are being exported beyond the border of the European Union and are being interpreted by bodies other than the European Court of Justice does not lead to different interpretations and ultimately to different pathways in applying these rules. And for this, you can either build in all agreements a structural homogeneity solution, like you would have, example, if there would be a common court between the EU and the other participant countries. However, that's what the Court of Justice has ruled out. So we're essentially depending on behavioral rules of homogeneity, as we have in the energy community in Article 94 of the treaty, which says whoever interprets European law exported from the EU to the energy community shall do this in conformity with the judgments given by the European Court of Justice. Well, this is an understandable and important principle, but evidently it doesn't help us in cases where the installations and also the legal questions very often are different from those that have already been decided in Luxembourg. That's another fact of life. No two cases are normally precisely the same. There is always a certain nuance, at least, that requires a proper interpretation. So homogeneity, very important, and it is always being pursued, at least as far as I can say from the energy community institution side. However, it doesn't result and cannot result in a mere copy and paste of dispute resolution decisions that have been already taken before. I would like to present you very briefly the approach developed for and in the energy community. Evidently, the energy community is modeled on the European Union. However, there are clear differences also to the EEA agreement. I mentioned that. There is no court. There are also not all the remedies that I wanted to present to you in the first part. So instead of preliminary rulings, instead of direct actions, what we are left with in the energy community is what you would call in the EU context infringement actions or infringement procedures. And given the absence of a court, they are of a hybrid character in the energy community. There's a very well juridified administrative procedure, so a procedure between the Secretariat, that's our institution, and the contracting party concerned until the moment it hits the table or the decision-making area, and that is a political body, not a judicial body, the Ministerial Council. So we have a juridified administrative procedure and a politicized decision-making phase of our enforcement or dispute resolution scheme in the energy community, and that's quite unique, I would say. It's important to look at the procedures and the players in a bit more detail. How does a case get to the Secretariat? Well, sometimes we discover instances of non-compliance by ourselves and follow up on that. But most of the times, and maybe more than in the European Union, the role of complainants, very often individuals and NGOs, plays a very important role. They are kind of antenna, or as you could formulate, they are private attorneys of the public interest in bringing potential cases of non-compliance, of non-respect to European rules to the attention of the Secretariat, and then it's the role of Smaranda, myself, and our other legal colleagues to be the machinery that transforms these suspicions and evidence into legal cases and bring them to the attention of the Ministerial Council, which is the one body that in the energy community replaces the Court of Justice, but not only that, it also replaces the parliamentary dimension and is, of course, the ultimate decision maker in political and any other legal connotations and contexts. So to speak of a separation of power here would be maybe a little bit far-fetched. Yet you cannot dismiss this political decision-making instead of a judicial one in terms of dispute resolution entirely, because what you do have also rules that bind the Ministerial Council of the Energy Community when they look into, when the ministers look into genuine legal procedures, so cases of non-compliance, is they need to decide by majority. So there's no veto of only one country, and the country concerned may not participate in the deliberation. And on top of that, any decision which would replace a ruling that they will take is binding on the country concerned, so not that different after all from what a judge would do, with the main difference evidently that the actors are politicians and not judges. In order to mitigate this default, if you wish, the energy community created an advisory body that many have compared to the Advocate General in Luxembourg, and these are 5 lawyers, European lawyers of the highest standing, presided by a president. It's called the Advisory Committee, which in every individual case gives a non-binding opinion to the politicians sitting in the Ministerial Council, advising them how to decide on that specific case in line with the European Court of Justice precedents. And that has actually worked quite well. There has been quite a significant body of case law also in the energy community. Maybe I can briefly mention that something where we are right now about to fine-tune the system and to develop it further is the penalty regime or the sanctions regime. There is only a political sanction in case of non-compliance by a country with a decision by the Ministerial Council. So if you would like to compare it to the EU, if a court, which in our case is a political body, finds you guilty of non-compliance with European rules, that's one thing, that's a statement, but it does not necessarily prevent those responsible for that from carrying on. So it needs sometimes sanctions and penalties, and that's precisely what's missing in the energy community in order to give the right incentive to actually comply with European law. And I may make another comment before I will give you only a few examples on how our advisory committee and the Ministerial Council replacing a court in the energy community, what kind of cases they had to deal with. Another comment which more generally relates to the future of these infringement procedures in the wider European legal space, because we are now in European energy policy, as many of you are aware of, in an age and in an era where to work with a lever and with a stick of infringement procedures may not be enough. We are about to embark onto the biggest economical and sociological revolution that the continent has seen since well over 100 years. That's the energy transition. And in order to do that, you have to do more than just applying pressure, legal pressure, and that's why we have evidently the will and wish to strengthen the European rule also in the energy community through treaty amendments, for instance. But we have to note that, for example, in the EU, the mothership of the energy community, the role of the Commission under the recent governance regulation, for example, is more moving into the role of an advisor, of a coordinator, than of a policeman. I think that's an interesting context to be kept in mind when we talk about the role of dispute resolution and enforcement in European energy policy. A few cases, as promised, and these are 3 very, again, subjective selected cases. The Ministerial Council had to decide on unbundling cases on the model of ISO, Independent System Operation, something that has not been yet subject to the European Court of Justice. It had to decide on destination clauses that matters from the perspective of competition law in intergovernmental agreements. Again, this is a novum, so the European Court of Justice has not yet decided on those. or also an interesting case in the context of climate change again, coal-fired power plant and the environmental impact assessment made for this coal-fired power plant in Bosnia and Herzegovina, which neglected the quantification of the greenhouse gas emissions, which then the Ministerial Council, supported by the Secretariat and by the Advisory Committee, found to be not in compliance with European law, this omission. Again, I think that links well to what Smaranda has explained on the international sphere. We evidently in the energy community would like to avoid disputes more than resolving them. That's why we cooperate also with courts and administrative authorities and try to help them very much in the spirit of what I just mentioned, to not go into disputes but to find appropriate situation. We are also, there is a certain link between what the energy community does in terms of enforcement and arbitration tribunals and decisions that then relate to these actions undertaken by our institutions here. I'm thinking, for example, of the now famous Stockholm Chamber of Commerce, Stockholm arbitration between Naftogaz and Gazprom, which to some extent had its origins in the energy community as well, because it was considered to be a contract, transit and supply contract, considered to be not in line with European competition law. And finally, and with this I'm handing back over to Smaranda, finally, we are evidently aware that a dispute, especially if it is affecting the larger economy and not only single projects, but is of a systemic relevance, can be an obstacle to reforming the energy of our contracting parties, and that's why we're helping them in mediation under the framework of the Dispute Resolution and Negotiation Center. And we introduced, Smaranda will explain that, we introduced a possibility in our own infringement dispute resolution procedures to negotiated solutions rather than to black and white, who's wrong and who's right solutions. Again, an effort to be made to settle and to fulfill one of the primary functions of dispute resolution, that is to bring peace. Thanks a lot, and with this, back to Smaranda.
Thank you very much, Dirk, and good afternoon again to the latecomers to our webinar. This is the last part, unfortunately, and it's the most interesting one, at least for me. And we're going to talk about our experience here in the Energy Community Secretariat in the mediation of energy law disputes. Now, in the previous part, Dirk was explaining this infringement procedure that we have with regard to the contracting parties. But what happens in practice during the years is that many times different staff of the Secretariat, Dirk or Yanis, our director, were requested to, facilitate discussions between various parties to energy disputes, which were arising in our contracting parties. So it was with time that we took the role of mediators between various stakeholders in our contracting parties, and the fact that the Secretariat has a neutral position, the fact that we do have the experts, we have the engineers and the economists, and we speak the languages of the area, somehow made us best placed in order to offer this neutral framework where different interests can be discussed and where parties with different interests could attempt and also come closer to each other. We have successfully mediated many disputes that could have escalated into serious conflicts, and some of them into year-long expensive arbitrations. You remember I was telling you about 12-year arbitration of ConocoPhillips versus Venezuela, and it's still not over. Such were the cases of, for example, EVN and Macedonia, CEZ and Albania, Gas Natural Fenosa and Moldova, and also the dispute between the TSOs of Kosovo and Serbia. This was just happening as a matter of practice, but then in 2016 there was a decision that we will formalize this ad hoc practice, and that is when a dispute resolution and negotiation center was established here at the Secretariat, attached by the legal unit and chaired by Dirk. This was the reason behind this, and our aim is to provide an alternative to arbitration and litigation. And it's nothing wrong with them, but as I was saying at the beginning of this webinar, energy disputes are extremely complex, and there is no one-size-fits-all. You cannot take the same dispute, and you cannot litigate all the disputes or arbitrate all the disputes. The complexity of the field requires tailor-made solutions. And one of the biggest advantages of mediation, not the only one definitely, but one of the biggest, is the fact that it preserves the relationship between the parties. And in a very sensitive sector, like the energy sector, this is extremely important for the countries and at the end for the consumers. I apologize again for the presentation which got blocked. Okay, so currently our work at the center is focusing on three main pillars, and the first one is the mediation of what we call third-party disputes. These are disputes in which the Secretariat is not engaged as a party itself, but the staff of the Secretariat, like Dirk or other colleagues, are acting as mediators. These disputes can be purely commercial disputes, but most of them are disputes between companies and state authorities. Then, as Dirk was mentioning, we have this infringement, this dispute settlement procedure under the treaty, but we are more concerned in reaching compliance as soon as possible, rather than going through lengthy procedures and having a negative decision against the contracting party. This is not our goal. So that is why we introduced the opportunity for mediation already at the very early stages of the dispute settlement procedure, so that the state authorities of the respective country and ourselves can sit together and then find a way towards compliance. And for this, we are engaging external mediators, so most of the time from a panel of mediators that you can find on our website. And then the last part is not so important for these purposes, but we also offer negotiation support and negotiation training to officials of our contracting parties. I will conclude with briefly presenting you a case, one of our success stories, and a very interesting case, successful mediation between what was then Gas Natural Fenosa, a Spanish investor, and the government of Moldova. At that time, Gas Natural Fenosa was Moldova's largest supplier and distributor of electricity, and the biggest, and probably only, foreign investor in the state of Moldova. The dispute arose due to some deviations between the cost of procuring electricity, which were in dollars, and the regulated electricity tariff that was paid by the consumers, which was in the national currency. What triggered this dispute was a financial crisis, a banking crisis in Moldova, somewhere between 2013 and 2014, when the local currency almost collapsed. And then what the regulator should have done at that moment was to adjust the tariffs timely so that they reflect this exchange rate difference between the national currency and the US dollars. For their own reasons, they failed to do that, but then the Spanish investor, which was paying for electricity in dollars and was being paid by the consumers in national currency, then of course incurred very, very significant losses. And it's not only the company, it's also the consumers. The consumers within a few months started being affected by this dispute, because due to this liquidity problem in the system, then the investor was not able to pay for the wholesale electricity suppliers. And then there were power cuts. So it's not just the company. Usually, you know, as I was saying at the beginning, it's a lot of actors and a lot of stakeholders that are being affected. what Government Fenosa did was to start arbitration proceedings I'm sorry, at the International Center for Settlement of Investment Disputes. And probably everyone knows already that in such arbitration proceedings, before actually going to arbitration, appointing a tribunal and so on, the parties, like the investor and the state, have to go through some mandatory period of negotiations. And it was during this period that the investor and the state came to us to help them find the middle ground and the solution to the problem, because arbitration, when you're talking about a GSO in a country, which is a natural monopoly, and this open conflict with the state is much more than a dispute about money. It would have been a collapse of the system. We started the mediation in February, I think, 2015, and it was quite fast. A bit over a year later, the state and the investor reached an agreement on these tariff deviations. At that time, the tariff deviations were estimated at $82 million, and the agreement was that they would be added to the tariff, but not immediately, but through a period of 4 years, so that the investor recovers its losses, these deviations, throughout 4 years. And then also this is good for the consumers, because the tariffs are not dramatically increased all of a sudden. And I would like to pause here for a moment and say that it is this aspect of the consumers in our work is incredibly important. Most of the times they're not part of the dispute, also in the big international arbitration cases. But it is very important always to keep in mind that they are, at the end, maybe not immediately, not the next day, but at the end, the most affected. And for every or most of the disputes, they are the ones who are paying the bill. So yeah, that was this case. It ended up quite fast. It stabilized the sector. It prevented an economic collapse and a social collapse in the country. And we are still engaged in other cases, some of them also in Moldova, also regarding tariff deviations, and we're trying to support companies and the state to reach this middle ground. And it's a very extremely interesting field, and it's also extremely rewarding when you finally manage to reach an agreement. So for the time being, that is all from us. Thank you very much for joining us for this very fast walk through the many facets of dispute resolution. And I hope, of course, you're going to join our colleagues for the remainder of our webinar series.